right. Well, good evening, everyone. I love a room that comes to kind of order and silence all on its own. So my name is Nagai Pendel. I'm the dean at the Peter A. Allard School of Law. And before we start the program, I would like to acknowledge that the UBC Vancouver campus is on the ancestral, unceded territory of the Musqueam people. I'd also like to acknowledge that many of you on Zoom may be joining us today from many places, near and far, and acknowledge the traditional owners and caretakers of those lands as well. So before we begin, just a few housekeeping items. If you experience any technical difficulties, please reach out via Zoom chat for assistance. Please be sure to direct your question to the host. We have additional colleagues on the line whose webcams are turned off, but they're assisting on the back end. Also, if you have any question for the speaker, please use the Q&A box to submit them. So, I'm honored to welcome you to the 2024 Marlee Kline Lecture in Social Justice. This lecture honors the memory of Marlee Gayle Kline, a member of the faculty community from 1989 until 2001. I didn't have the good fortune of knowing Marlee personally, but I've heard wonderful things about her scholarship. And this lecture is a wonderful opportunity to reflect on her impact on the law school. So after losing Marlee far too soon, her colleagues, students, friends, and most especially her family came together to establish this annual lecture. Marlee's work on feminist legal theory and critical race theory, child welfare law and policy, law's continued colonialism, and restructuring of the social welfare state is internationally acclaimed. Marlee insisted on a complicated, intersectional understanding of the law and the world. This lectureship not only recognizes Marlee's rich contribution to the law school community, but it also reflects her passionate belief in the central role social justice plays and must play in legal education and the law. And now, it's my pleasure to invite Margot Young to the microphone to share more with you about Marlee Kline. Margot Young is a professor here at Allard and is the current director of the Law School's Center for Feminist Legal Studies. And her involvement with the Marlee Kline Lectureship goes back all the way to the beginning. And so with that, please join me in welcoming Margot.
Thank you, Dean Pendel. And I want to welcome everybody to what is the 20th anniversary of the Marlee Kline Lecture in Social Justice. Dean Pendel has introduced me already, but I want to add to that that I was a close friend of Marlee, and she was a very dear friend of mine. So I always welcome this annual event because it gives me a chance to speak about Marlee and to celebrate her work and her contributions to the Legal Academy generally, but to this law faculty in particular. Marlee died of leukemia at the age of 41. In her struggle with cancer, Marlee was, as she was absolutely everywhere else, determined, forthright, and brave. A few years after Marlee died, a number of us, as Dean Pendel has mentioned, came together to establish this lecture in recognition of the commitment that Marlee had to social justice. And that was a commitment that showed itself in her scholarly work, in her larger professional world, and also in her personal life generally. Marlee's work at this law school persists. Her mark on the law school persists in the integration of Indigenous laws and perspectives into the curriculum and in the opening up of feminist analysis to intersectional perspectives. Marlee challenged her feminist colleagues to integrate analysis of systemic and structural racism into their feminist work. But Marlee was a joyful friend. She was an inspiring colleague, but she was a joyful friend. We played Dungeons and Dragons together, but we also plotted curriculum for the social welfare law courses we were each teaching at our then different law schools. Really, Marlee was a cherished colleague and a close friend for many of us at this law faculty. And the enduring success of this lecture series in her honor attests to a very wide circle of people and a range of communities where Marlee made a difference, where she has had an impact and she was loved. I want to take this opportunity to thank the donors who have made these 20 years of brilliant feminist presentations possible. The list of donors is long. Over 200 of Marlee's friends, colleagues, and communities from across Canada and wider contributed to ensuring that we have this annual talk in her honor. But I want to single out Marlee's family, because their donations to this series were the sort of anchor for making it happen. They also donated to enable us to name the Center for Feminist Legal Studies room the Marlee Kline Room. And the Marlee Kline Room has become a critical and an important space to support and nourish, and I mean literally, because we always have tea and cookies available in that room, to support and nourish our diverse feminist students. So thank you to the Backens and Klines and to other family members who have made tonight possible, and to all the donors, in fact, who've made tonight possible and made also possible the 19 other talks that precede tonight. Your contribution has been critical to the vibrancy of the intellectual life of our law school, so thank you for that. And I'm going to do something that's a bit unusual, but I just want to acknowledge some of the family members who are here in person and also online. So I want to, and I'm just going to mention you by first name. You know who you are. I want to acknowledge Joel, Marlee's partner at the time she was a professor here, who's on Zoom. Mayim Blackett Kline, Marlee's beloved son. Ronnie, Marlee's brother, and his partner Ruth. Sandy, Marlee's sister. Rebecca Jenkins, who's currently mother to Mayim and Joel's partner. Laura Kline, who is sister-in-law to Marlee, and particularly Kara Kline, who's Marlee's mom. It's wonderful to have you with us tonight. It's very special. So I mentioned that this is the 20th anniversary of this lecture series held in Marlee's honor. And I want to mark this moment. So I couldn't fit on one slide 19 faces and presentations. I can't capture the full diversity and richness of with tonight's lecture, 20 years of this lecture in social justice, the Marlee Kline Lecture in social justice, but I want to give you a flavor. So bear with me, first of all, as I show you 12 of the 19 speakers that precede tonight, and I want to read just a few of the titles to give you a sense of the range, the depth, and the vibrancy of what this series has brought into the law school. So Donna Young, who's currently dean of another law school, her talk was Say Her Name, Law and Activism at the Intersection of Race and Gender. Jacinta Ruru, a New Zealand scholar, spoke about honoring our ancestors in law, legal personality, and Indigenous governance of lands and waters. Bonnie Scher Klein, a disability rights activist, spoke about I am who you are. Jean Taillé, a Métis scholar and lawyer, the Métis of the Northwest, finding justice for invisible people. Ruth Ann Robson, a close friend and an American legal theorist, had a talk called Unsettled, the links and dissonances amongst 5 colonial, post-colonial societies. Tracy Lindbergh, a Canadian Indigenous scholar, talked about deconstruction, Canadian law, and Indigenous women. And Dee Dee Herman, who was our second speaker in this series, and again, a very close friend of Marlee's, talked about an unfortunate coincidence, Jews and Jewishness in the English courts. So we've had, as you can see from this very small sampling, an amazing program across the 19 years up to tonight. And of course, we're going to add to this list another impressive, amazing women's scholar. So we're fortunate to have Professor and Dr. Adelle Blackett give tonight's lecture. And I have to say, from a personal perspective, this is such a success for me because we've been trying for 3 years to get Adelle. And we finally did. And every year, I'd send around, I'm going off script here, I'd send around an email to my colleagues saying, give me some ideas for the Marlee Kline Lecture. They always wrote back and said, get Adelle Blackett. And I'm like, I'm trying, and finally we did. So I'm feeling very jubilant about that. Professor Blackett is in huge demand, as you're going to see from the very few sort of smatterings of details I'm going to give you about her accomplishments in a moment. But I just want to say thank you first to Adelle for making this happen and being here with us. I know you have such a busy schedule. She came in last night. She's taking the red eye back tonight. Such is her commitment and generosity towards us. We're just thrilled to have you deliver the 20th anniversary presentation in the Marlee Kline Lecture in Social Justice. Professor Blackett is a professor of law and the Canada Research Chair in Transnational Labour Law at the Faculty of Law at McGill University. She's an elected fellow of the Royal Society of Canada and has so many honors that have come her way that I'm just simply going to summarize them by saying she is the recipient of a number of honorary doctorates, prestigious awards, and visitorships from around the globe. Professor Blackett, as if that wasn't enough, she's also widely published in the field of transnational labor law with a focus on decolonized approaches or decolonial approaches. And in 2019, she published what would become an award-winning book, Everyday Transgressions, Domestic Workers, Transnational Challenge to International Labor Law. Professor Blackett's current research, oh, and I have a slide, sorry. Professor Blackett's current research focuses on slavery and the law. And tonight, the title of her presentation is The Fierce Urgency of Now, Transforming Employment Equity for Us All. I'm going to let Professor Blackett tell you about the work out of which this talk comes, but it's part of the reason she was too busy up until this point to come to us. So this really marks a kind of milestone in your accomplishments and a moment to celebrate for you in terms of having a couple of years of very hard but important work. But let me ask you then to join me in giving a very warm welcome to Adelle Blackett. Without instructions on that.
Unfortunately, that stopped the
Does everyone else have to enter back into the webinar? They're online.
should be still sitting. You're in the webinar. And it's still there. That's a good sign. Do you want to take the slides down completely?
Yeah, that was what I was trying to.
Take the whole view.
I don't know, what's a talk without a comic moment?
Okay, so we're good. Yeah. Sorry, hold it. Your microphone works.
Wonderful. Does it work? Can you hear me? Fabulous. It's okay. It's great. It's great. It just strengthens my resolve. First, for thanking you most sincerely for such a warm welcome, and Dean Pindai as well for welcoming me to the faculty. I'm deeply honored to be giving the 20th anniversary edition of the Marlee Kline Lecture in Social Justice. Marlee Kline started teaching at UBC when I started studying law at McGill in 1989, and her early engagements with indigeneity and her deep understanding of racism in feminist theory gave me hope. As a student, social justice, far from an abstraction, was written into the life of law. I hope this presentation, which aspires in that tradition to be at the intersection of social justice scholarship and advocacy grounded in lived experience, honors her legacy and wish to acknowledge with gratitude the members of her family who have done the honor of being present here today, in person and virtually. I also wish to acknowledge the traditional unceded land, that of the Musqueam, the Squamish, and the Tsleil-Waututh nations. I underscore this acknowledgement as the descendant of enslaved Africans in the Americas, because I believe that history matters, perhaps more than ever now. The Allard School and I have also shared a history, and yes, I too looked back when I was preparing this talk and recalled the generosity of spirit that you approached the challenge I was facing. The picture you have up is one I no longer use because it's from the pandemic, but it reminds me of just how long ago it was that you have generously been waiting for my 500-page Employment Equity Act report that I will speak to you about now. And it is explicitly about social justice, so much so that in its introduction, it quotes the Reverend Dr. Martin Luther King Jr.'s urgent vision of an equitably inclusive world as something that's far from optional, I would argue, in our country, in a country that's as deeply plural as Canada. And in this challenging world moment, it stresses the theme of mutuality. And in Dr. King's words, we are tied together in the single garment of destiny, caught in an inescapable network of mutuality. Whatever affects one directly affects all indirectly. For some strange reason, I can never be what I ought to be until you are what you ought to be. So employment equity is a proactive approach to achieve and sustain substantive equality in the workplace context. It's urgent, and it takes all of us. The Employment Equity Act report was 2 years in the making. Of course, a ton of research, international comparative, data-driven research, but also extensive consultations were consulted. And here I must underscore the absolutely remarkable team of 12 people who came together during the pandemic, and most of whom I've still not met in person. So you will appreciate the emotion that I feel that one of the members, Josh van der Veld, a UBC law graduate, was able to attend today. So thank you, Josh, for being here and for your enormous contribution to the deep learning that characterized what we did. Our focus was on meaningful consultations, and in the spirit of the work that we conducted was, if you listen deeply, you will learn a lot. And people from across the country came, met with us, and engaged deeply, in some cases underscoring the depth of the disappointment that they experienced in their own working lives, but their conviction that things needed to change in the Canadian context for the next generation. They wanted to tell us something. They wanted to tell us about how much our framework matters to them and how much we need to move forward.
Turn the volume up. People are hard to hear you.
Yes, and I will project. I can do that. Yes.
I'm reluctant to touch anything.
Yes, maybe we should hold on just a second. I'll project in the meantime.
I think I'm okay.
Feedback, though. I think we might get feedback with this. Yeah, thank you.
Maybe.
Yeah. It's okay. I'm happy to project. Wonderful. Thank you. So one of the insights engaged at the outset and that we took to heart is that history really matters. So first, a bit of history on the legislation. And accounts rightly begin with the visionary Rosalie Abella, then a judge, now retired Supreme Court of Canada Justice, who coined the language of employment equity and understood the significance of moving us past a vision that had come to predominate because of the US framing of affirmative action. She did that while at the same time drawing quite closely on US understandings of adverse impact discrimination through the Griggs decision. So a bit of a double move there. So on the distancing that we still had to underscore in the report, she moved us away from a logic of reverse discrimination. And through something, of course, I'll talk about a fair bit tonight, through an understanding of substantive equality and the distance that that takes from treating all people the same, captured what it is that was necessary to be able to remedy discrimination. So remedying, or indeed reversing discrimination, as central to how we understand substantive equality. She also emphasized the importance of moving away from a reactive mode to addressing employment equity to a proactive framework that nonetheless could be put in place with attention to goals and action on the part of workplaces without getting trapped in what had become a bit of a red herring around quotas. So she called for 4 equity-seeking groups to be identified: women, and in the wording of the time, Aboriginal peoples, visible minorities, and persons with disabilities, and framed that group understanding out of, again, a longer history, including our history of language rights. As many of you will recall, our first employment equity program, if you will, was in the federal public service, and it was about inclusion of francophones, right? And so that framing allowed this 1984 Royal Commission report, and then the legislation that ensued in 1986 with a major reform in 95 to become ensconced in what I'd say is literally our self-understanding, right, in the workplace. And indeed, in the consultations, there was virtually no challenge to the idea of employment equity. And we consulted very widely, right? Very widely. Okay. So a crucial contribution, an important move, so much so that when we started to hear groups claim that really we didn't want equality, we wanted equity, right, and dichotomize the two, it became apparent, just one, how important employment equity as a frame was. People understood the need for equity. But two, it became pretty apparent that we had not managed to communicate just how substantive our understanding of substantive equality is, and why that is the conception in the Canadian context. So more about that. I want to pause, though, because the history of employment equity, I would argue, is deeper still. Right? And certainly the history of a more transformative approach to employment equity that underscores the role of the groups themselves, equity-seeking groups, equity-deserving groups, in the history of settler colonialism, of residential schools, its legacies that we're coming to terms with now through missing and murders Indigenous peoples and dispossession, cultural genocide, intergenerational trauma, and the need to engage truthfully with reconciliation. There are pieces of that history, pieces of that memory, that thinking about employment equity in the context of Indigenous self-determination that we start to see. One is of Haudenosaunee Confederation of Six Nations Cayuga Chief Deshkahe, who in 1923, 1924, traveled to Geneva and petitioned the League of Nations for recognition of self-determination, for recognition of a framework that I argue forces us to think more capaciously about what it is that we're trying to accomplish when engaging with Indigenous populations, Métis, First Nations, and Inuit peoples in the Canadian context and in the context of the UN Declaration on the Rights of Indigenous Peoples and Canada's international obligations. The second is in the history of slavery and segregation. And the first, there's a longer version of this discussion that finds its way through the text of this report. But one example that kind of epitomizes this for me is that the first Black Canadian woman and African Nova Scotian appointed judge is Corinne Sparks, who in 1987 attended segregated grade school. That recent a history, right? The fight against legalized segregation in Canada is a relatively recent fight. It's one that's chronicled in great detail in a recent book, Cecil Foster's They Call Me George, focusing on the industry that should unite us, the railways, and chronicling the borrowing, if you will, transnationally, of patterns of racial segregation that were familiar to the US, right, in the Canadian context, and that can only be understood in relation to broader patterns of segregation. Many of you might have taught or might teach the Christie v. York decision, which in 1939 our Supreme Court of Canada rendered, and that gave legal recognition to segregated patterns of service delivery in the Canadian context. And historians writing about that time underscore that it's not that that was exceptional to one tavern in one city, Montreal, but rather that the patterns were widely understood and members of Black communities in the regions just knew where not to go for service. and this particular tavern had changed its pattern. This pattern was similarly part of other laws and legal texts, including, of course, in the labor context, written into collective agreements. And labor law reform along the Wagner Act model was not enough to counteract these practices. You needed human rights law, but that was not enough either. Reactive models were not enough to redress patterns of underrepresentation. And so as early as the 1950s and 60s, you had calls for proactive legislation that would acknowledge exclusionary histories and foster equitable inclusion. Okay, so a broader history, and I could, of course, spend the entire talk underscoring some of the histories. I'll mention in passing the history of the Chinese head tax, the history of internment of Japanese Canadians during the Second World War, the history of the purge of 2S LGBTQI+ people in the federal public service, for which Canada has only recently apologized, and the history of a purely medical model of disability that has ultimately reinforced a deficit model of disability rather than a focus on barriers in context, and that have prevented people with disabilities and all historically marginalized groups who are seeking equity from achieving it. Histories, in other words, that have led us to recognize that equity is deserved, in the words of Dr. Wisdom Tete, who is a U of T Scarborough principal, deserved in the sense that it incarnates the principles of human dignity, of substantive equality, and of restorative justice. Though the histories remind us of why employment equity must be understood not only as human rights law, although of course it is human rights law, and groups came before us asking, in fact, for it to be explicitly stated that the legislation is quasi-constitutional, but that it's also labor and employment law, part of making workplace inclusion meaningful, equitable, not a complete response to workplace undervaluing, but part of the response to a distinct set of workplace problems. And to give a very basic example, but an ubiquitous one. When's the last time you talked to a taxi driver and been told that the taxi driver has a PhD, is an engineer facing whatever challenges, and we have in our statistical information counted those workers as taxi drivers in terms of representation, and in the process missed the ways in which that very classification reinscribes the kind of underrepresentation that they face, the kinds of labor market exclusion that they face. Okay. So, bit of a check here. The report covers federal legislation, 8%, less actually, of the 2020 Canadian labor force. So ultimately, the impact is symbolic, but the impact is also outsized in relation to who it covers. It covers the federal public service, and many of the core sectors that are seen as defining or uniting us. And it also serves as a model for other jurisdictions, especially in the field of labor relations. So a sector whose impact has been crucial for thinking about the possible and illustrating how that is possible. And indeed, the only other jurisdiction in Canada with comparably comprehensive coverage on employment equity is actually Quebec. Right? Okay, so a lot of space in the post-pandemic period for some level of rethinking. What happened? Why is it that we are in a context where to state that employment equity 40 years later, or just about, has not been achieved? Why does that seem like even an odd thing to consider? Right? Why is it that we are at once uncomfortable stating it, but it seems obvious? And I would suggest that the reaction in a context that's as pluralist as ours is actually the source of concern. Even more so in this world moment, if we're not able to deliver on a vision of what it means to have a society that meaningfully includes a range of members of our society in a manner that challenges rather than reinforces stereotypes, that removes workplace barriers, and that sees the seriousness of our necessity to represent ourselves to ourselves through transformation. So if employment equity is truly proactive, why is it treated like the hospital after the crash? Why is it reduced to numbers crunching exercises that have lost touch with the actual lives of the workers from historically marginalized communities? And we were really struck by the extent to which bureaucrats who were well-intentioned but were following path-dependent approaches wound up producing more and more detailed assessments without any real connection to what was happening in the workplace, and perhaps just as importantly, without much of a connection to the people, the actual workers who were inhabiting the positions that were being assessed. Why this approach that lost touch with what we stressed as central to employment equity, and that is an approach that focuses on the barriers themselves, an approach that focuses on the workplace rather than the numbers alone, an approach that takes substantive equality so seriously that it actually starts to understand that if we're not engaging with transforming the spaces, we're recreating the exclusions. One of the challenges, and this might sound surprising, or maybe it'll be a relief. I'll see from your reaction. One of the challenges was the framing around EDI and the concern that it might be becoming something of a distraction away from a framework of substantive equality a framework that should actually focus not necessarily on multiplying actions, an unconscious bias training here, right, another initiative there, but on actually achieving and sustaining equity in employment. We were worried, in other words, about a loose, somewhat ephemeral set of actions that were non-performative. So the quote from the report that has gotten a lot of play speaks to this. It's often said that diversity is a fact, inclusion is a choice. But in the Canadian context, we really should be emphasizing that equity is the law. And this is not only, it is the Employment Equity Act, right? It is that substantive equality, our constitutional understanding governs how we approach our work. Okay. So a lot of attention since the report was released has been placed on the recommendations to establish 2 new employment equity groups for Black Canadians, recognizing history and underrepresentation. And to take only one example from the data, fully 16% of Black workers with a bachelor's degree or higher from a Canadian institution work in occupations that require a high school diploma or less. This is the highest overqualification rate of any Canadian educated racialized group. The average for Canadian educated populations was closer to 11%. And the rate for Black workers is similar across generations and across genders. For 2S LGBTQI plus members, a multiple group estimated in the most recently released and historic, because of the questions asked, data collection by StatsCan, comprises 1 million people, or 4% of the Canadian population, whose shared history of discrimination and marginalization has led to solidarities and struggle, and for whom the data available are, to say the least, deeply imperfect, somewhat of a chicken and an egg problem. There's a need for data collection, but despite that, the data point collectively, and I would say compellingly, to underrepresentation, prevalence of discrimination, harassment, and exclusion, including barriers at hiring, faced by 30% of transgender women, 22% of transgender men, in a recent 2021 non-randomized survey conducted by the Government of Canada, indicating that they'd been denied employment due to their gender identity. The government has also announced some quite welcome changes in name for Indigenous peoples with a clear distinctions-based focus on First Nations, Métis, and Inuit peoples, racialized peoples as new terminology instead of the universally loathed language of visible minorities, and crucially changing the definition of persons with disabilities to adopt the barriers-focused approach in the Accessible Canada Act. So these commitments came in December. They were received as somewhat of a bomb in a very difficult time. And they will be most welcome by many when passed into law. But the report, which is the first comprehensive report to have been issued since the Employment Equity Act was established, goes much further. And it focuses on a transformative framework with several of the elements I've already raised, namely to ensure that employment equity, like pay equity, like the work under the Accessible Canada Act, is expected to actually be achieved and sustained with a global timeline and measures in place to achieve that. But mostly, and I've alluded to this already, a crucial shift. And that shift is to take seriously the call for substantive equality to be understood in relation to transformation. And in this sense, reclaiming some of the power of admittedly a high watermark in our human rights jurisprudence, the Majoran decision, and that we've seen in similar iterations in occupational safety and health decisions, also at the Supreme Court, this case by Justice Abella herself in Dion, decisions that emphasize the need to focus less on the individual complainant and how they might be accommodated individually, and more resolutely on the workplace itself and the normative focus, how that takes us towards thinking about where the barriers are to equitable inclusion and how they may lead to transformation. And so the report builds a three-pillar framework. First, on barrier removal, and in relation to that, takes us through or builds upon the work in a previous chapter on data justice. That chapter builds, I think, quite crucially on the work that's happening here in British Columbia on how you collect the data that you need to be rendering, to render a deep understanding of societal exclusion, including on the basis of race. So starting with the grandmother principle articulated by the BC Office of the Human Rights Commissioner, and then these underscoring the human rights purpose of employment equity, data collection, and a shift that accompanies that, where certainly the numerical data remain important, but there's a focus on data that are at once qualitative in nature, taking lived experience seriously throughout the process, and then disaggregating data that pertains to the intersectional categories that have gotten lost in the processes. So for example, one of the reasons for the claim for a separate employment equity group for Black Canadians was that employers could literally fill the visible minority category and never hire a single Black person. And data to this effect were brought to the attention of the task force in aspects of the federal public service. Right. So deeply challenging need to capture both how the data are being collected, what we're being able to understand by using data that are disaggregated, and thinking about what justice looks like for communities that have faced systemic oppression through the data, not taking, in other words, as a starting point, that data collection is a neutral for communities, right? That it needs to be understood purposively. And so in relation to that then, taking the time doing the work necessary to ensure that the barriers are deeply and carefully understood in a comprehensive manner. And one of the aspects that we sought to do in completing this report was also to take into account the voluminous work that had been done before us on various aspects of this. I've already mentioned Justice, or the Honorable Corinne Sparks, and the report quotes a 1993 report that she did for the Canadian Bar Association Task Force on Gender Equality. And she foregrounded what she heard from Asian Canadian women lawyers who found themselves closeted in research-related jobs in the profession. And those lawyers talked to her about one of the stereotypes they faced in the profession, that they were somehow perceived as not aggressive enough to litigate. And Judge Sparks understood that the stereotype went deeper than just stating that. Indeed, to the very definition of what we think a good lawyer looks like, sounds like. And of course, the model was built around another image, an image that predominated in the profession for centuries and left unchallenged. It's the model that would continue to exclude a lot of talented, committed lawyers from equity groups. And so, and she asked rhetorically, who defines the characteristic of being a good lawyer? How do we avoid continuing to perpetuate this? But the focus is that it's the norm. It's the workplace norm that needs to be the focus of our attention if we're attempting to act proactively. Otherwise, we continue to repeat the exclusion. So rethinking essential qualifications becomes crucial to that process. Rethinking merit becomes crucial to that process. And there's a lot written about rethinking merit. Some of it is drawing the pieces together, and it might or might not surprise you that one of the most powerful recent iterations of this flows through the Honorable Michel Bastarache's report on sexual harassment in the RCMP, entitled Broken Dreams, Broken Lives. And in it, he argues that ignoring merit can, of course, at times worsen harassment and discrimination, but of course, we cannot assume that merit is neutral. We cannot assume it's objective. It might, of course, be highly subjective, and we need to be intentional and careful about how we understand it and how we enhance merit by taking equitable inclusion, i.e. representation, very seriously. And in this case, by looking at international and comparative examples, found that, surprise, if you're going to be an RCMP officer and seriously engage with sexual harassment, you need more specific qualifications. You can't just be the generalist who gets hired all the time. Right? So really careful rethinking that then does something quite fundamental to the way that we think about underrepresentation. So when we say tokenism, we're completely missing that what's really at stake is the discrimination that leads to underrepresentation in the first place. We're keeping our gaze on the underrepresented and perpetuating a deficit model. A transformative approach forces us to look carefully at the institution and the institutional environment and ask ourselves how we include. Okay. As you can tell, it's a 500-page report for a reason, but I don't want to keep you for the time it would take me to get through a 500-page report. So I'm going to just talk briefly about the two other pillars: meaningful consultation and, of course, regulatory oversight. The meaningful consultation piece was so important, and yet we kept hearing about top-down approaches to equity, right? We'll just fix it, right? We'll, add this and change that. But we won't actually turn our minds to the groups who have been excluded as those who might know how to fix the problem, or at very least want to be involved in what gets done. So there's a jurisprudential way to this, and certainly in respect of First Nations, Métis, and Inuit peoples, UNDRIP, Section 35, and Supreme Court of Canada decisions lead us to a place of a robust understanding of what a duty consult means, what meaningful consultations mean in that context. Similarly, through labor law, again in international law, as well as our increasingly robust Section 2D jurisprudence, we're getting a clearer picture of what meaningful consultations mean. But when you really boil it down, what groups were saying to us is the mantra that has captured the disability rights movement and has been claimed by most historically marginalized groups, and that is nothing about us without us. That simple, and yet that crucial if you're taking seriously the need to recalibrate in a way that acknowledges the harm that has been carried out unintentionally, but in the past, and the need to move towards a model that is representative. And while we heard a lot from groups that said things like, oh my goodness, am I ever tired of being asked what I think about X, Y, Z? Am I ever tired about being surveyed? But we really want to be meaningfully consulted. This is, of course, a collective voice model that most were expressing. And so we propose a joint employment equity committee and really rethinking what it means to be including the historically marginalized. And finally, the regulatory oversight pillar. And I'll just give you two examples that I was somewhat incredulous about. So Section 5 of the Employment Equity Act reflects the duty on employers' part to implement employment equity. But that provision has been interpreted for almost 40 years to mean they produce reports, but they don't actually have to show that they've made progress on implementing. And so I was gobsmacked, and I thought, wow, okay, we need to fix this. And then, it would turn to the French version. And then we would say, clair comme de l'eau. It says, what do you know? The employer, and this is my translation, the employer is required to ensure that reasonable progress is made in implementing its employment equity plan. So, okay, 40 years of never looking at the French version. So, and look, we in a Human Rights Commission, there's a bifurcated institutionalization. Human Rights Commission federally is responsible for audits. Labor program is responsible for implementation through exchanges with employers and helping them along and providing the logistical tools and the like. And there's only 11 people in the Human Rights Commission auditing the entire federal jurisdiction. And then we learned the audits are not shared with the labor program. Not only that, I realized I was one of the only people to actually have seen the audits outside of the Human Rights Commission and the individual concerned employers. And employers, if you were a betting employer, you could say, well, not much is going to happen until the audit. And if I get audited, then it looks like I'm starting from zero. So some fundamental challenges around the support for equity. We're not thinking about equity the way we think about some of the other governmental priorities. There's nowhere near the kind of resources that you have, for example, for an auditor general. And yet the magnitude and nature of the work is vastly similar. And so there's a clear importance to rethinking that work. We proposed a commissioner, of course, but we're really attentive, particularly in this context where our Federal Human Rights Commission has been found in an internal grievance to have discriminated against its own employees, that there's a need to take seriously the kind and nature of the institutionalization, and we expressed a preference for building out an office of proactive equity that would include accessibility and pay equity, both of which also have a commissioner. So this is the specific of how you begin to rethink a model in a way that calls on it to rethink our constitutional commitments to substantive equality and our international law commitments to achieving substantive equality. But one of the overriding themes, and this should not surprise us in law, is that law alone will not get us there, right? This is so much more. It's about understanding who we are and what our aspirations are as a society. It's about the ability to look at our labor market that surely the pandemic helped us to see the remarkable stratification along lines of historical marginalization in the work that's done, and to not take it as natural, as fixed, as just the way our world has to be, but as something that we should be centering in how we act on truth and reconciliation, how we act on substantive equality, how we act on building a strong democracy, not despite the context of rising populism, but because of it. Uppermost in the reflections then of our entire task force was how you inhabit a commitment to understanding our mutuality, how and where we are going in precisely this moment, how you build the kind of rooms like this room that when you walk into them, you know that we all belong. So thank you for listening.